Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph Jordan, the founder over at Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here is a former Army JAG, worldwide court-martial defense attorney. He's tried more than 240 court-martials to verdict, and he's handled hundreds of military cases all across not only the United States, but Europe, the Pacific, and the Middle East. Today's episode, we're going to be continuing our conversation on voidier, jury selection, this time looking at how jury selection works in the military. It's very different than the civilian system, and what Joseph has been really paying attention to when a panel is being convened. Joseph, it's good to see you as always. So we're going to move now, right, from the civilian jury setting into a court-martial setting. What's kind of the first difference in panel selection that stands out to you?
Good morning again, Mike. The first difference. Well, I think I haven't tried a civilian case. I've only sat as a juror, as we talked about in the last episode. And I think the first difference that I could see that's the most salient is our questions in the military of members are really geared towards bias. And most of the military judges ensure that the questions are geared specifically towards bias. The military judge spends a lot of time ensuring that we don't get into what he believes is his territory. So when we get into talking about the law or instructions, that's an absolute no-go. The military judge won't let us do that. In military court, we actually have to draft out our questions prior to showing up in court. The judge will then go through and determine what's allowed and what isn't. Both parties are allowed to review each other's voidier questions, and we're allowed to object to them if we don't like them, and then maybe there's some litigation over that. But for the most part, the military judge, that's his courtroom. He decides what he allows and what he doesn't. Some judges are very restrictive. Most judges are pretty liberal. They'll allow you to really dig into and figure out where the bias is, but they're very strict about that. They're not going to let you get into discussing the law.
You know, one other difference that I was just thinking of right now, in the military system, the panel doesn't come from the community at random, right? Like you would see with civilian trusts. Like, how does knowing who selected the panel kind of change the way you approach the voir dire process?
It's not necessarily knowing who selected the panel. It's looking at the actual population of the panel. It's always going to be, the convening authority is always going to be, the first CG in that particular unit, right? So it's going to be a 1-star, 2-star, 3-star general that has a pool of members that they pick from. And then everything's randomized. They're getting more and more towards a civilian type of system to make it more, at least have the appearance of being more fair. And I think when I look at the jury selection process, I'm usually not that concerned about the pool of members and where they're coming from in terms of who selected them, right? In the civilian sector, it's totally random, right? You're picking names out of a hat. In the military, there's a set group of people. It's usually 100 to 200 names, and then they're randomized from there. So you got about 200. So it's similar. You got a population. You're randomizing that population, and then the first 21, 22 individuals in that population that were randomly selected are brought in for general voir dire, and then we pare it down from there to get to 8 if it's a general court-martial.
So Joseph, continuing on that, because all the makeups of these folks, there's rank, there's different professional backgrounds. It can matter, right, in a bunch of different ways. What kind of patterns are you paying attention to as you're getting a sense of who's in the room?
Sure. So from a pattern standpoint, we're looking at, are any of these individuals in the same chain of command as another individual? And we see that more often, right? So if I've got a commander and then I have an executive officer and then I've got, a platoon leader, for instance, or I have a commander and I have a first sergeant, or I have a brigade commander and his command sergeant major is in there, or a battalion commander and his operations officer is in there. We're looking for those types of things because then just by virtue of them being in the same chain of command doesn't mean that that one or the other is going to be viced off. It is a marker. It is something that we look at. It is something that we question them on, but it's not necessarily indicative of bias, at least not from the military standard. So we have to look at other things. And so ahead of time, we actually get data sheets on the members themselves, and we learn a lot of things about them. We learn their education, where they went to school, how long they've served, are they married, do they have children, where they've served, what duty positions have they held, um, whether they've been in command or not, for how long, have they sat on a court martial before, have they given non-judicial punishment on Article 15, have they sat on boards, have they been a part of an investigation. And with commanders, we look at, have you had individuals prosecuted for the crime that my client's being prosecuted for? We look at that because commanders are a part of the military justice system. They make recommendations as to whether or not a case can go to trial or not. So we're really interested in what their experience is, and we're also interested in their judicial temperament. We really want to know and understand, how are these guys really and truly thinking about cases, how they processed them in the past, and we're looking to ferret out kind of their thought process to determine if there's any internal bias with the way they operate in past actions.
You know what else is also interesting to me is that military panels, they have like a shared common experience, right? Like it's a little bit different than a civilian jury. I could be next to somebody, we have different walks of life, right? How does that shared culture kind of influence the way the panel members are listening to you guys and listening to the evidence that's being introduced?
I think it helps, to be honest. You know, you're all from the same culture. You can speak their language. You can speak in terms that they understand. Particularly with the Army, I'm always going to be the most comfortable trying an Army case than any other service, because the Army has its own culture. I grew up in the Army. I served 11 years in the Army, both as an enlisted soldier and as an officer. And so, and in a variety of capacities, in a variety of units. So you get a really good feel for how different individuals process information. Um, and over time, over the last 15 years of private practice, I've learned the Navy, the Marine Corps, the Air Force, and the Coast Guard, uh, and kind of their nuances as well. And so understanding how they receive information, if you're coming from a particular, within the Army, if you're coming from, let's say, the engineer corps, right? Engineers process information differently than, say, an infantry soldier does. So how do you message to them? That's important. You want to know how to properly message to one vice the other. And oftentimes, you don't have a full deck of one particular branch in the panel. What I mean by that is, I'm not going to have a full panel of engineers. I may have 5 engineers, 2 MPs, if they survive voidier, and a bunch of medical officers, right? But the culture of the Army is the same. The culture of the Air Force is the same. So if you understand that, you know how they receive information, then you can message in accordance with that.
Let me expand a little bit more on that because I'm sure when you're questioning these panel members, you mentioned before about the bias angle and removing that. What in that instance helps you kind of separate people who can evaluate the case independently from those who you may feel are going to pressure to defer to others?
So first and foremost, I'm looking at their backgrounds to understand how they got to where they're at in the service at this point, right? So with officers, there's a number of ways that you can get a commission. You could get a direct commissioned out of the civilian population. Those individuals tend to be a little bit more independent thinkers. You could be, you could come from the enlisted ranks and go and be commissioned as an officer. They also tend to be a little bit more independently thinking in the way they operate. Um, Academy grads, we look to see if somebody went to the Air Force Academy, the Army, went to West Point, went to the Naval Academy. Those individuals tend to be more indoctrinated, but not always. And so you have some preconceived notions before you go in. And then, of course, if you've done this long enough, you understand the culture. You get a senior non-commissioned officer, some sergeant major that's been around for, almost 30 years. They tend to be also really independent thinkers, but there are tells where they're not, where they're a little bit more indoctrinated. So you really have to pay attention to the answers to the questions. So your questions are carefully tailored to get a sense for how they think. How do they process information? Are they giving me a canned? Are they giving me a canned answer, or are they giving me something that has some thought to it? Not just thought, but original thought. Right? What is their original thought process? And so my questions, when I'm doing general voir dire, are very carefully tailored to get at their original thought process. And if they don't have one, that is a red flag for me.
Well, expanding on a little bit of that, of what you just mentioned, these military panel members, they only have what's presented in the courtroom, right, to work with. Right? Like a civilian jury, you may have potentially have heard of the case, and it could impact or sway something, right? Which is what voir dire is supposed to weed out, right? So how does that reality kind of shape the way you approach voir dire in a court martial setting?
Well, certainly, that's actually one of the questions. Are you aware of the case? So I think the judge has a list of like 26 questions that they ask. I think that's actually one of the judge's questions, but we always usually ask a question very similar to that to determine, have you heard of this case? In the military, we have status briefings for misconduct, and senior leaders sit on those status briefings to determine, what's going on the base, those sorts of things, and cases are discussed. So we always ask about that. Hey, have you sat any of these meetings? Has my client's case come up? Those sorts of things. So we ferret that out at the outset. And so there's really no concern that somebody sitting in the panel knows something about their case, because if they do, 9 times out of 10, they're off the panel.
Can you share a case where something you noticed during voir dire later showed up in deliberations or even at trial? What did you recognize early on?
When you're questioning members, you really want to understand kind of what their overall thought process is. And there's not any one particular case that I can point to and say, hey, look, here's a great example of how this works, because so many of the members that we are able to get in the jury box, they're the right member for the most part. It's rare where we get a situation that we look at a member, we don't like that in member, but there's really we don't have a good reason to get them off the panel. And the reason why we might not like the member isn't anything that they've said in the courtroom. It's intel that we've gotten on them from the outside, and it's information that we can't necessarily question the member on in the courtroom. So, what I can tell you is we like members that are inquisitive, and there is one case that sticks out. I had a dual child sex assault case in Ramstein, Germany, almost 10 years ago. And it was kind of the worst case scenario where you're talking about someone that's a neighbor. The kids know the neighbor, that sort of thing. And we had a lot of senior leaders on the panel. We had to, because our client was an E7. So they had to be E8s and above on the panel. This is an Air Force case. And we got the sense that through the voir dire process that we had some inquisitive members. And in the military, one of the unique things about court martials is members get to ask questions. In my experience as a juror here in the state of Texas last year, I actually asked the judge, "Hey, can I ask a question?" And the judge looked at me and laughed. It's not a thing you do in civilian court. I was like, "Oh, okay." And then he caught me after everything was done. He was like, "You do military." They knew that I did military justice. They knew that I was a criminal defense attorney for the military. He's like, "So that's a thing?" And he's like, "Yes, it is." And the unique thing about this court-martial was we had 52 questions over a week-long trial from the members themselves. And that definitely shaped that changed my closing argument a little bit. Because think about it. If you have 52 questions from the members, what is that? That's 52 opportunities for reasonable doubt. And after 16 hours of deliberation, that was a full acquittal.
It's great insight into the way the military panels are convened and how the whole process kind of unfolds. You know, Joseph, as we put a bow on this episode, for people that have been listening to this series, they've been following along, staying with what we just talked about, what should they understand about why panel selection in a court martial is one of the most consequential phases of the trial itself?
Well, those are the individuals that are going to be making the decision on whether or not you're guilty or not guilty. And that's it. They don't decide the sentence anymore. That's a recent change under the UCMJ. Only the military judge does that. But they're the ones that are going to be deciding, are you guilty? Are you not guilty? And so you want to make sure you have the best 8 in that box as possible. And I'll tell you, voidier is one of my very favorite parts of the court martial process. You learn things about individuals that some of the things that our service members do for their country is absolutely amazing. And you learn a lot about what different people are doing. And that's really important too, to understand what it is that they do, because that informs how they think, how they process information, and how they're going to look at your case. And so when you're sitting down and getting ready to prepare for trial, I actually involve my clients. I ask them, I show them the members' data sheets. I show them the members' list. Hey, do you know any of these individuals? Do you know of these individuals? Because it's their case. And they get to choose whether or not they want members or judge alone. So if they choose members, then it's incumbent upon counsel to ensure that they properly vet these members, properly question these members, to ensure that you have the best 8 in the jury box.
Joseph, thanks for the time, the insights, explaining all this to the audience. I appreciate it as always.
Thank you, Mike.
And thank you to everyone out there for listening to this episode of Courtroom Quarterback with Attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, visit jordanucmjlaw.com today. Don't forget, before you go, like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.